What are reservations on international human rights law treaties? Imagine a world where countries agree on fundamental rights for all individuals, but some states want to keep certain rules flexible. This is where reservations on international human rights law treaties come into play. Reservations are formal statements made by a state when it signs, ratifies, or accedes to a treaty. Through these statements, a state seeks to exclude or modify the legal effect of specific provisions of that treaty as they apply to that state. This means that while a state agrees to be bound by the treaty overall, it does not accept certain obligations within it that it finds problematic or incompatible with its national circumstances. This approach allows states to participate in human rights treaties while maintaining some flexibility. Reservations often arise because certain treaty provisions may conflict with a state's domestic laws, cultural practices, or political priorities. By making reservations, states can avoid full legal commitment to all treaty requirements while still benefiting from being part of the international human rights framework. The legal foundation for reservations is primarily found in the Vienna Convention on the Law of Treaties from 1969. This convention defines reservations and sets rules for their formulation, acceptance, and objections by other states. Key principles include that reservations must not be incompatible with the object and purpose of the treaty. This means they cannot undermine the fundamental goals and integrity of the human rights protections the treaty aims to establish. Other states party to the treaty may accept or object to a reservation. Objections can affect the legal relationship between the objecting state and the reserving state. Reservations must be made at the time of signing or ratification and cannot be added later. States may also withdraw or modify their reservations over time, which can improve treaty compliance and strengthen human rights protections. From a liberal perspective, which emphasizes political freedom and individual rights, reservations present both opportunities and challenges. On one hand, they enable broader participation in international human rights treaties by accommodating diverse legal and cultural contexts. This promotes universal norms of individual rights and due process. On the other hand, reservations can weaken the uniform application of human rights standards and potentially allow states to avoid key obligations, which may undermine the protection of individual freedoms and legal rights. International human rights treaty bodies play a critical role in monitoring reservations. They assess whether reservations are compatible with the treaty's object and purpose and encourage states to withdraw or amend reservations that are considered inconsistent. This oversight helps balance state sovereignty with the liberal commitment to uphold fundamental human rights universally. In practical terms, reservations influence how human rights treaties are implemented within states. They may limit the scope of treaty provisions, create variations in legal obligations among states, and affect the effectiveness of international monitoring and enforcement mechanisms. Understanding reservations is essential for appreciating how international human rights law operates in a world of diverse legal systems and political cultures while striving to protect individual rights and due process as core liberal values.